also, we have a wonderful speaker. I'm so glad to see her again today. And this is Julie Gafkay. And she is just well-renowned, excellent. She is from the Gafkay Law firm. And Julie, Julie practices law throughout the state of Michigan and is located centrally in Saginaw County. She's practiced as an attorney since 1995, and her main focus is employment discrimination law. She has done an outstanding job. She's an award winner. I'll tell you something about some of her awards. She has won the State Bar of Michigan Champion of Justice Award and just around a couple of years ago. Michigan Women in Law Award, Top 50 Women in Michigan, Saginaw County Bar Association Community Service Award, Saginaw County Pro Bono Service Gold Award, Thomas Ruder Super Lawyers List, and Marquise Who's Who World Edition. Wow, are we ever privileged to have Ms. Attorney Julie Gafkay here today. So Julie, I'm gonna go ahead and turn it over to you. And if you could please just get started however you like, and we'll sit back and enjoy your presentation. Thank you.
Thanks, Vanessa. It's always a pleasure to talk to your group. You're an excellent educator for the human resource field. I'm sure all of you are part of her LinkedIn family, and I enjoy seeing everything you push out. I love your videos on LinkedIn, and I share them often. So thank you for everything you do for the human resource community.
I really appreciate it.
And I appreciate that Vanessa is willing to have me speak to you, because I'm really an employee I know that human resource generalists and managers are advocates for employees and the employer, but my practice focuses on representing the employee. So a lot of times I see you folks on the other side of the table. So when I'm doing depositions and when I'm involved in lawsuits. But a lot of times you have advocated for employees, you've advocated for the regulations and rules to be followed, and sometimes the management just doesn't take your advice. So kudos to all of you for continuing to educate yourselves and be part of this organization. It's gotten a lot harder for you as human resource managers and generalists and individuals over the past year, much harder. Your job was already pretty darn hard with all the employment laws and regulations and laws relating to benefits. But now we're going to do a whole session, not just on EEO law, for instance. In fact, we're not even going to talk about EEO law. We're going to take a whole session and talk just about COVID-19, which wasn't even a phrase prior to 2019. So I'm sure that you have faced a lot of challenges in the workplace with COVID-19. You already were very challenged with all the laws and regulations that you had to contend with. So hopefully this makes it a little more easier to do your job. We're going to be talking about a variety of things that impact the employment place due to COVID-19. We're going to start with just a quick overview of the federal laws, which for the most part have fallen off. A lot of those expired in December of 2020. More relevant today is the Michigan COVID-19 employment law, which was passed in October of 2020. And that does have a significant impact on the employment practices today. And we're going to talk about that. I've got some information we can touch on the current orders from the Michigan Department of Health and Human Services and how that affects employment. We can talk about the MIOSHA regulations and how that impacts employment. I have some information to share with you about vaccinations. And in that vein, we are going to actually talk a little bit about EEO laws because it impacts individuals with disabilities. It may impact individuals with religious beliefs who don't want to be vaccinated. We're going to talk a little bit about employee privacy because I know that that's a big concern if you're in human resources. What can we say to others? Now all of a sudden you're supposed to be talking about or asking about people's health conditions and taking temperatures and doing things like that, which never before have you had to do in human resources. So, and we're not going to talk much about unemployment, but I could just briefly touch on that. Obviously, the pandemic unemployment assistance, that was a big deal in 2020. That was the additional $600. That's basically expired. However, Michigan is providing a supplemental $300 from January through March this month of 2021 for $300 additional up and beyond the 326, which is the maximum weekly benefit we're at now. So that's all I'm going to say about unemployment, because we have a very packed schedule with just what we went over just now on COVID regulations and laws. Vanessa, we didn't go over this before. Am I able just to share my screen?
I believe so.
Okay,
I believe so,
we'll try it, and then you might have to give me permission. We'll say, oh no, you've already done that. So I'm going to pull this up. It's a little slideshow on COVID-19 laws and regulations. Hopefully it will make it easier to take notes or to follow along. But as I said, the first thing I wanted to touch on is just, as you know, on April 1st, almost a year ago, the CARES Act was passed, the Families First Coronavirus Relief Act, that whole package, that bazillion trillion dollar package that was passed by the federal government impacted employment. And specifically, the Families First Coronavirus Relief Act, which provided 80 hours of paid leave, and that act exempted healthcare providers and first responders. Now, that has essentially expired. However, the only thing I want to say about that is, so that was the emergency paid sick leave, that 2 weeks that, and we're going to go over on the next couple slides what employees that applied to, when an employer had to give when the employer had to give the 2 weeks. If an employer employs 500 employees or less, this law applied, however, did not apply to healthcare workers or first responders. And it has expired. However, if an employee took time off for the reasons we're going to state, between April 1st and December 31st, 2020, that employee still is eligible for 2 weeks. Now, it's only 2 weeks. So if you've already paid the employee 2 weeks, you don't have to pay the employee anymore. So these were the reasons that employees could get that 80 hours of paid leave if he or she could not work because the employer was subject to a governmental quarantine or isolation order, or the employee was unable to work due to a governmental quarantine or isolation order. If a healthcare provider advised the employee to self-quarantine, or if the person was experiencing symptoms and seeking a medical diagnosis. And the employee under this Families First Coronavirus Relief Act, you get 2/3 of your pay for up to 2 weeks for these two reasons: caring for an individual who is self-quarantining or someone diagnosed with COVID, if someone's caring for that person and they have to take off due to that, or because they're caring for a child because the child is unable to go to school or childcare. So again, though that law has expired, but if you didn't pay the employee for 2 weeks and the employee took 2 weeks off during last from April 1st to December 31st, 2020, that employee would technically still be eligible. This also was something in the CARES package, the Family Medical Leave Act Expansion Act. It applies again to employers with 500 or less employees. This expanded the Family Medical Leave Act, and not only so, under the Family Medical Leave Act, an employee can be unpaid for up to 12 weeks for a qualifying event. Under this expansion, actually an employee is paid for 10 weeks at 2/3 his or her salary. And again, this is expired, but just wanted to go over what applied due to COVID last year for you, in case you had some questions about that. So what applies now in Michigan on October 21, 2020, the COVID-19 employment law was signed into law. And so now it is applicable to the employment. It still is in place. This is not something that's going to expire. At least it doesn't have an expiration date. So it applies currently to the workplace. So let's talk about that, because it's pretty important. This gives employees, I mean, there are some rights in this law that are built in for employers, frankly, as well. But this gives employees an extra layer of protection if he or she is unable to work for the reasons enumerated under the statute. So basically, an employer should not discharge, discipline, or otherwise retaliate against an employee who complies with Section 5. Section 5 is in the next slide, but who displays symptoms of COVID-19, even if the employee later tests negative and takes off. If an employee, so there's also an anti-retaliation provision in the statute. So if an employee complains about non-compliance of COVID regulations, of COVID safety precautions, things like that, that employee has a right to do that without being subject to retaliation. Now, what are the employer's rights? So if an employee, claims he or she has to be off due to COVID, the employer has the right to advise the employee to get a test within 3 days, and to provide those test results to the employer. So you do have the right to request that the employee get tested if he or she is saying they have the symptoms of COVID-19. And fortunately for employers, the testing is much, much better now than it was, several months ago. You can get rapid tests done. You can find out results relatively quickly. Even when it's not a rapid test, typically results can come back within a day or two. So this adds more work on human resources, but it allows human resources to have accountability with employees who claim he or she has COVID-19 symptoms and needs to be off. So the reasons that an employee can be off or should be off, in fact, the law says an employee who tests positive or displays the principal symptoms, and you can find out, and I'm sure that you have, the principal symptoms have been changing, okay? As we learn more every day, every minute, we learn more about this, right? So you should go on the CDC website and look up the guidelines as to what the principal symptoms are. So those do change. But if an employee displays the principal symptoms or tests positive, the law actually says that employee shall not report to work. So this puts a burden on the employee that says you're not supposed to report to work. So the employer should, obviously not encourage that employee to report to work because it's not allowed under the statute. The employee can return to work once the following conditions are met. If the employee had a fever, 24 hours has passed, or if the employee tested positive, 10 days has passed since the symptoms first appeared or since they received that positive result. And the principal symptoms of COVID-19 have improved. So when those things happen, the employee can return back to work. So somebody asked the question before, and it was a very good question. One of the issues our company would like to address is employees saying they were in close contact with someone who is COVID positive and requesting quarantine. We have been advised to not ask for supporting documents to determine if the employee is in fact telling the truth. So that is a complicated situation, and
Yes.
I guess the best advice I could give is if there is a reason to believe that the employee is fraudulently representing that he or she came into contact with someone who is COVID-19 positive, then I think certainly you can look into that more. And I think that some questioning of the employee on why he or she believes that they had contact with somebody who is COVID-19 positive, why they believe that they had exposure, I mean, just because you were, let me give you a for instance. Just because you were in a restaurant 10 booths away from somebody and that person apparently was positive for COVID-19 doesn't necessarily mean you had exposure to that person, I don't think. I think that it's okay to, if the person got a call from for instance, if the person got a call from the Department of Health and Human Services, a contact tracer, and the contact tracer said, by the way, we want to tell you that you came into close contact with somebody, they're not going to give you the person's name, but they're going to say our contact tracing is. So contact tracing, if somebody is telling you came into close contact with somebody else, there's a reason the Department of Health and Human Services is calling you. So that's certainly, and I don't know that they give documentation, they make a phone call. So whether that employee could get the documentation is questionable.
He was at Johnson alone.
So
Could I call Michael Fetcher and see if he'll work there?
I guess it's a circumstance where it might not always be possible to get the documentation. I think it's reasonable for the employer to ask questions to figure out what that basis is of that employee who is saying he or she came into contact with somebody. So, if the employee has supporting documentation, you can ask for that. I'm not sure what that would be. A redacted positive. You're still taking the employee's word for it because you can't. I don't know that the employee is going to be able to get a positive test result documentation from the person he or she had contact with. So, the incentive for doing that really is down. In other words, you don't get paid under this Michigan law. You get protected, not paid under this law if you have to take 2 weeks off to quarantine because of exposure. So unless the employer provides that any employee who is quarantined or off due to COVID-19 a positive result, that employee isn't going to get paid. And that emergency paid sick leave act that applied in 2020 no longer applies, the one we just went over. So it's not as incentivized as far as pay. And so, you know, certainly some questioning of that employee. I hope that answers the question. I know it's a complicated area, and certainly, you know, just like FMLA, you just want to be, you know, you want to be sensitive, but you also want to be practical. You certainly can follow up if there's reason to believe there's fraud, you know. I mean, certainly if this person flies to, you know, Cancun for a 2-week vacation in correlation with telling you they need time off because of a quarantine, and that person doesn't have any vacation time left, I mean, obviously there's an issue. So, so that we've talked about that, you know, the person should have 14 days off under the statute if he or she has had close contact with somebody with the principal symptoms or a positive test. So who doesn't the law apply to? The law does not apply to healthcare professionals, if somebody works in a healthcare facility, a first responder, a child protective service employee, a worker at a child caring institution, somebody who works in an adult foster care facility or a correctional facility, somebody in the energy industry. There are a lot of categories of employees who are not covered under this. So if you're unsure, you should look at the law. But if one of these areas is the employment that you're in, you may not be required to allow 2 weeks off for exposure, for instance. And that's really the practical reason, because if you can't allow a healthcare worker, I mean, under policy, it would be impractical to say that a healthcare professional who comes into contact with somebody COVID-19 positive gets 14 days off every time he or she comes into contact with somebody who's positive, because, you know, people may be coming to that facility for care because he or she is positive. So it's just against policy, and it's impractical. So those sectors of employees are excluded. So I am going to actually go to a couple charts that I pulled up online, and you can pull these up too, but this is from MIOSHA. So we're just talking now about creating a safe work environment as required under the MIOSHA guidelines. So these rules that I'm showing you now took effect October 14, 2020, and they're in effect for 6 months. So they're still in effect currently. And many of you may have already done a lot of this, but specifically creating a COVID preparedness and response plan. So if you have not done that and employees are back at the work site, you should go to MIOSHA, has information and templates on creating a preparedness and response plan. And it lists what's required. So you should implement actually a written plan that discusses these various things, you know, barriers between the worker and the exposure to the virus, putting administrative controls in place, having policies and procedures. For instance, you know, a lot of employers are staggering the work schedule for minimum contact. A lot are allowing teleworking and increasing social distancing. Your preparedness plan can address hand hygiene, surface disinfection, the use of personal protection equipment, health surveillance, in other words, you know, screening protocols, you know, making sure that employees who are reporting don't have the symptoms, the principal symptoms, or, you know, taking the temperature of employees, training, providing training. You should also have, and it may be a lot of the people at this meeting who are identified as this person, but you should identify a workplace COVID-19 coordinator. And that person is really the go-to as far as compliance. And, you know, masks should be and are required. So that's important that is enforced. And making sure that the workplace is clean and safe, that there's procedures in place for sick employees, require employees to report not allowing employees to report when they receive a positive test or experiencing the principal symptoms, and employee training. Now, in the MIOSHA guidelines, there's specific industries that have additional or different guidelines for safety protocol. So if your business falls within one of these, you know, you should look to that for the specific guidance. And it really depends on how much contact and exposure you're going to have. So there's just some elevated requirements depending on that. So I would recommend that you, if you haven't already, go to MIOSHA and make sure that your business is in compliance with the MIOSHA rules and regulations. So we have a lot of agencies that are involved with COVID compliance, COVID regulations, and a lot impacted. The other big one is obviously the Michigan Department of Health and Human Services. And since in 2020, we started out, in fact, in March of 2020, with the state of emergency being declared. Hard to believe that it was a year ago, but it was. I was thinking about how this morning I went to Starbucks and got my coffee. Last year, almost exactly a year ago, I was at Starbucks sitting at a table, working on my computer. Other people were around, you know, people were talking, nobody was wearing masks, nobody knew what COVID-19 was. Then all of a sudden by the afternoon, I went to get a refill and they were pushing tables to the side, stacking chairs, and declaring that they were closing because the governor had just issued an order that by 3 p.m. Restaurants had to close that afternoon. That was on March 17th, but close enough. So now we had a period of time where the governor was issuing executive orders that was found to be unconstitutional. And then the governor stopped issuing the orders, and then the Michigan Department of Health and Human Services started issuing the orders and advising regarding the regulations, which certainly is not unconstitutional and within the purview of what the Department of Health and Human Services does. And so we should, they have been issuing and pushing out these guidelines. This is I think the most recent one. I just looked at it this morning. It's dated February 8. It could be dated, but for the most part, I think that it's probably the most recent one because frankly, there's a lot open. I mean, it's every place is essentially open. You can't go to a water park in Michigan. I mean, they do have indoor parks, but I certainly wouldn't want to go to an outdoor park anyways at this time of year. But the nightclubs are still closed. And for the most part, as you know, employers who have employees who can work remotely and do work from home are highly encouraged, well, in fact, told those employees should be working from home. And that's a more difficult call to make. I do think that employers, for the most part, have been doing a good job trying to figure out which employees can work from home and which can't. And there are obviously pros and cons to that. And we're learning that. So once we are managing COVID-19 better, once we've attained herd immunity, so to speak, and we can choose which employees work at home or not, I suspect that a lot of employers will have employees working at home that weren't originally working at home prior to COVID-19 because it's cheaper, because it's more efficient, because the employee's happier, and because it's working. So some good has come from the forced changes in the workplace. That may be one of them. But this chart is not one that I created. This is on the Michigan Department of Health and Human Services. And they have some great, they have other charts too, and they have signs. So you don't have to create a sign that says masks required. You can go on that website and print off the masks required one they have on there, and it's very, very well done, and it's universal because it's used by a variety of employers. So we'll go back to the PowerPoint here and talk about something that really is ramping up here, and that's vaccinations. And it's, starting Monday, the state of Michigan, you can get vaccinated if you're 50 or older. And so that's really going to increase the numbers of people being vaccinated. And that's a good thing, hopefully. But not everybody is thrilled about being vaccinated. Not every employee wants to be vaccinated, and employers don't necessarily know what to do about vaccination. So as employers, as lawyers, I have to look at what is the existing law on, immunizations, vaccinations, medical exams, all those things existed prior to COVID-19. So they still apply to our analysis as to whether vaccinations are required or what protections. So as an employment lawyer, the first thing I want to look at is a vaccination a medical examination? And why that is important is whether it's defined as a medical examination is because as you may know, the Americans with Disabilities Act protects employees and creates layers of protections for medical examinations. So the EEOC, the Equal Employment Opportunity Commission, which pushes out guidelines on following the Americans with Disabilities Act, has said, you know, that vaccine is not a medical exam. Requiring a vaccine is not a medical exam. And so it takes away some of the protections of a medical examination. That's what that means. So what's important is, if you can ask, but what is protected is, so pre-screening questioning may fall into a protected category for the Americans with Disabilities Act, okay? So the mere you need to get vaccinated, and you can't force an employee to get vaccinated. I mean, in the sense that you can't hold an employee down. I mean, it's just like at-will employment, you know, like we got to use our common sense. I mean, an employee doesn't have to get vaccinated. You don't have to be vaccinated. But if you not getting vaccinated potentially could cause a direct harm to the employment, then your choice is fine, but you can't work here, may be acceptable, maybe. And the key is what I just said, and that's, is that employee a direct threat to the workplace if he or she does not get vaccinated? So you need to look at that. And if the answer is yes, then you can require the employee to be vaccinated. If the employee chooses not to be, then the employee is going to have to either work remotely, if possible, not work there, or lose, you know, have some time off, whatever, or lose his or her position or job. Now, if you're the employer and you're going to provide the vaccination, you have to be careful though, because in the process you're going to be doing, there's, you know, pre-screening questions which could violate the Americans with Disabilities Act, unless those questions are job related and consistent with business necessity. So in other words, if the vaccine is necessary for the job, then the employer could arguably require the vaccination and administer the vaccination and ask those pre-screening questions. If you're not sure whether it's job related and consistent with business necessity to administer the vaccination to employees, then all you need to do as the employer is just have a third party do it. Don't do it yourself. Just send the employee to a third party. That third party asks the pre-screening questions. The employer never knows the answer to those pre-screening questions, and the employee is vaccinated. So, you know, for instance, they're doing that with teachers now. They're sending them to be vaccinated. They're going to a third party to be vaccinated. And it's required, frankly. So, but here, you know, there are some employees who are going to choose not want to be vaccinated. And there are a couple circumstances where an employer should consider an exception for some employees. For instance, if an employee claims he or she cannot get vaccinated, does not want to be vaccinated due to some disability, and requests as an accommodation not to be vaccinated, then the Americans with Disabilities Act requires you as the employer to engage in what's called an interactive process. And all that means is that you talk with the employee, you know, about why do you need this accommodation, you know, and figure out if that person should be exempted from having to be vaccinated. And again, the key is, you know, if that person in not getting vaccinated would cause a significant risk of substantial harm to the health and safety of the individual or to others, and it can't be eliminated in any way, then you don't have to grant the accommodation. If granting the accommodation, which would be not getting the vaccine, is reasonable, then you should grant the accommodation if requested and the person does have some type of medical condition that he or she is able to show, you know, prohibits or precludes or makes the employee leery about getting the vaccination. The other reason that some employees may try to use is to say that he or she has a religious belief. I don't know how far you want to push that as an employer. Legally, it has to be a sincerely held religious belief. So the key is it has to be sincere, and you are justified in asking for documentation for that. So you can certainly do that if somebody is asking for an exemption. So that deals with vaccination. I know that's a big issue for everybody right now. I also know that privacy concerns is one of the biggest issues. So we hear about the word HIP, you know, I think HIPAA just is generally a term used when anybody's talking about somebody's medical issues. Really, it only applies to healthcare plans and healthcare providers. However, a lot of employers turn into, you know, HIPAA entities that HIPAA applies to because they have healthcare plans, and so they administer the employee healthcare plan. And so that turns you into being required to comply with HIPAA. So understandably, a lot of employers believe, and rightfully so, that HIPAA applies to them if they administer healthcare plans. Regardless, even if you call it HIPAA or you don't call it HIPAA, we'll just call it privacy. I mean, privacy concerns, because generally speaking, when you're talking about health issues, those are very private matters, and those are issues that employees are going to be concerned about, and employers are going to be concerned about disclosing to others, asking about. And now we're in a whole new world, and now all of a sudden you should ask about these things. And so the issue is, how much should you ask? What should you ask? Things like that. So every employer should require all employees to disclose to the employer whether they have tested positive for COVID-19 or been in contact with somebody who has tested positive. That is okay. I mean, I think we all know that now, but it's good to be reassured that it's okay for you to ask an employee. And it's okay to ask an employee if he or she has the principal symptoms, and you should know those symptoms. And again, those symptoms change. So I recommend you go to the CDC website and look at the most recent principal symptoms. And in some instances, it has to be 2 or more of the symptoms. For instance, having a stomach ache alone is not a principal, is not symptoms of COVID-19. It's that in conjunction with a second, for instance, a stomach ache and a headache, that would be symptoms of COVID-19. But only having a stomach ache, for instance, is not symptoms of COVID-19. So it's good to be up to date on what symptoms are. And sometimes, and actually the Michigan law that I showed you earlier, and I'll get the exact, it's 423 something, but I'll go back and give you the site for that so you can look it up. That actually, in the definitional section, I believe, has what I'm talking about right now. It has the symptoms. It has, in some circumstances, that you have to have 2 or more of the symptoms, and one is not enough to suggest that you have COVID symptoms, which can prove to be important because, you know, a lot of times employees have, not everything is related to COVID. You know, an employee may have a stomach ache because an employee has a stomach ache, ate something bad the night before, not because he or she came into contact with somebody, or not because he or she has COVID, but because they ate something bad. So, but going back to the privacy issues, now so what we were talking about, whom should we inform if 1 or more employees test positive for COVID-19? So now you have a situation where an employee actually contacts you and says he or she has tested positive. Now you should disclose to other employees that a coworker or a visitor has tested positive, but you should do so without identifying that person. And what's the first question that somebody's going to ask you if you say, there's been a coworker who's tested positive for COVID-19 and you had exposure to that person? First questions you're going to get is, well, who? Now, with an employer of 100 employees, you may not be able to figure that out, you know. With an employment site with 8 employees and Mary Jane is gone, everybody probably knows it's Mary Jane, but you don't need to tell them it's Mary Jane. You just tell them, I'm not going to tell you who, I'm just going to tell you you've been exposed. So maybe and likely they'll be able to figure that out if it's a small employer, but it's not your job or it's not your legal responsibility to tell them or identify the person. An employer should not disclose the identity of the employee who's tested positive or any of the specifics about his or her medical conditions to others in the workplace. So that, I think we had okay. So we had, we had another question before the seminar or before today's meeting. And I think we're talking about privacy issues right now. So somebody says, is it a HIPAA violation to say to the office staff, she is not in today, she has a sore throat due to COVID concerns? Is it a violation to say to the office staff, she is not in today, she has a sore throat due to COVID concerns? I think it's just repeated, sorry. I would stop it, she's not in the office today. She's not in today, period. I mean, people don't need to know why. People absolutely don't need to know if it's COVID related or not. What they need to know is whether he or she has been, whether other employees have been exposed to somebody with COVID, whether it be a visitor, you know, a vendor. I mean, obviously, on a day-to-day basis in employment, you're coming into contact with people other than the coworkers. So, but that's what they need to know. so that is my advice. But you should still disclose if somebody has been in contact with somebody else with COVID in the workplace. So Vanessa, we finished a lot sooner than I thought, but I mean, we've been talking for at least a half hour. I'm happy to take questions and I'm happy to talk more. I thought it would take longer, but your
But that was
attendees have been great.
your presentation was awesome, excellent as usual, Julie. And Katrina, are you around?
Yes, I'm here, Vanessa. I can't turn my camera on at the moment. I'm having
Okay.
some things done in my office, but yes, I'm here. Hello,
I was
everybody.
wondering if you mind reading those questions that came in for Julie.
Sure,
Thank you.
no problem.
And Katrina is one of our board members. Everybody pretty much knows. So go ahead, Katrina. Sorry.
No, not a problem at all. And this question comes from Lori Curtis, and it reads, does leaving work to get a vaccine fall under the no discipline policy?
No, that's not covered by the Michigan law. So
Okay.
that's a short answer, although my hesitation is, and I understand that, you know, my hesitation is because I'm thinking you should let that person go. Get the vaccination if he or she has the opportunity to get the vaccination, because
Right.
that will create a safer workplace for you. However, you can't just have anybody leaving whenever they want, right? I mean, I think that certainly if somebody is working, they have deadlines, they have clients, they have whatever, they have stuff to do, meetings, and all of a sudden he or she gets up and just walks out the door and says, I'm getting a vaccination. You know, I mean, certainly that's disruptive. That's not protected. That needs to be addressed. But I would balance that with, you know, kind of a stick and carrot thing. You know, you want to give them a carrot to get the vaccination. So, you know, one of the ways to do that is if there's a way that you as the employer can try to help the employees coordinate getting the vaccination just by providing information. For instance, you know, on Monday, I don't know where you can get the vaccinations. I'm sure that that information can be discovered. I don't know what times you can get the vaccination, but you could push that information out and just say, you know, you can get the vaccination from 8 a.m. to 9 a.m. We encourage you to get it, and we, you know, that's when you should get it. If for some reason you have no other way or other time to get it other than during work, you need to get that approved. And then you said, is having the right to request a test the same as require?
Mm-hmm.
Oh, you mean requesting them to tell you, you mean requesting the test when there's a claim that they have the symptoms, and you say that you take that 3-day period to say, we want a test result? That's not the same as require. Those things are not the same, but I understand why, you know, you would put those two things together. So requesting the test within the 3 days that we talked about under current Michigan law, that's under the statute, and that's legally allowed by the employers. Requiring the test has not been legislated. There's no statute I can point to that says Michigan law actually mandates that employees are required to get the vaccination, or this law says specifically that you're allowed to require it. We're figuring that out based on the laws that exist, and So I don't know if that answers your question or not, but those
Yes,
are
it does.
different things. Okay, good. Those are good questions.
Yep, that made it clear. Thank you.
So I can look at I'm looking at the chat, Vanessa. I see there's some questions. I don't mind looking at the question and reading.
Oh,
it.
okay. Go right ahead, Julie.
So what if your company and DOL mandates corrective action occurs if someone tests positive for COVID, contracted probably at work? Oh, corrected. I guess I would ask, stating the employee violated the safety policy and COVID guideline, is that considered retaliation? I see what you're saying. So the Michigan law actually mandates that an employee not report to work due to COVID. So if an employee knows he or she is positive, gets a test, let's say an employee got a test on Monday and had symptoms and tested positive and reported to work Wednesday, 2 days later, still having symptoms or just have gotten the positive test result. And by Monday, there's 5 other people who have tested positive for COVID-19. I think legally you could issue some type of corrective action to that employee. I mean, you'd have to figure out why you want to do that, I think. I mean, that person, if I'm sure the preparedness plan that you have in place tells employees don't report if you are COVID-19 positive for at least 10 days. That's the current statutory time. 10 days and you have no symptoms. After 10 days, you can report if you tested positive. So if the policy says that, the law says that, and you report, what is the reason you're reporting? If that person reported because his or her supervisor told him or her to report, that's a different story. If that person reported because that person just didn't know or understand, I guess that would be a different story. But if that person just is being insubordinate and totally just disregarding the positive result and the policy, certainly that is something you may want to consider doing as corrective action. And your question is, would that be okay? I think. Well, you're saying, I don't know that the DOL, maybe the DOL guide, I've not seen that guideline. I'd be interested in seeing that if it mandates corrective action. I mean, corrective action could be as simple as telling that person to get out of the workplace. Okay, so that could be mandated. Corrective action can mean a lot of different things. I think in HR world, we view corrective action as some form of discipline. Corrective action or mitigating action could be get that person off the work site until they've gotten through the 10 days, for instance. I hope that I answered that question. The next question is, are employers able to store a copy of the vaccination record in the employee's medical file? So I assume, I think the simple answer is, my legal opinion would be yes. You already have sensitive medical information in that file, unless you as the employer administer the vaccination to the employees, which is, I think, the exception, not the rule. I think typically a third party is administering it. So what's happening is the employee is bringing you a piece of documentation that says, I got vaccinated. I mean, that would be the best place to put it. You shouldn't put it in the employee's regular personnel file. You should segregate it and put it in that medical file, just like you have other ADA documents. And like we said, it's not a medical exam, but to provide the employee with the most protection possible, segregating it and putting in that medical file would be best, I think. So I think the answer to that question is yes. I do remember this from last time, Vanessa. Your group is very good about asking questions, so I appreciate that. We do have another question that just came on the screen. Do we have the ability to request a copy should the vaccination become required? I mean, a copy would just be that the individual is providing documentation of the vaccination. I think the answer to that is yes. I mean, I think that, I don't think that that would interfere. I mean, and I think the employee, yeah, I don't think you could just say to an employee, did you get vaccinated? He or she says yes or no. I mean, that's just subject to, it's easily verifiable. You should get that verified. That's something that would be easy to lie about too. I mean, yeah, I got vaccinated, you know. I mean, what are you going to do? Show me your shot spot. I don't even know that that shows a I don't know. I haven't gotten vaccinated, so I don't know. All right, we have another question. I have my first employee exposure to COVID-19 of 2021, who is currently quarantining for 10 days. Actually, it's 14 days under the law that they should quarantine with exposure. Are we legally required to pay her by state or federal law, or is that up to the employer to develop a policy moving forward since the expiration of FFCRA? So that's, yes, so that's what I was saying, and you're right. You don't, there's nothing legally requiring that that employee be paid. You know, the unemployment issue is such a moving target. So Michigan is still, again, having that supplemental. So likely you may be able to get unemployment for that 2 weeks. I don't want to say for sure, because the person is unable to work due to circumstances beyond their control. In other words, they had contact with somebody, they were exposed, but you know, the employer could pay the employee, but again, it's not legally required, you know, unless that employee has vacation or sick pay that's available that has been banked. And you're correct, right? The FFCRA, that 2 weeks, which is also referred to as the emergency paid sick leave, that 2 weeks of pay is no longer applicable in March of 2021. It expired in December of 2020. So the short answer is, in my legal opinion, no, you don't have to pay that person. So that's, are there more questions? These are very good questions.
Yes, they are. Well, Julie, I really, 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 really appreciate you. You know, always I do. And I think you do an awesome job. I hope you'll come back when you get a chance. And I think did another question pop up? I don't think so.
Just you thanking me. It wasn't a question.
Oh yeah, everybody's thanking her. So let's just give her a quick round of applause if we can. Excellent, excellent, excellent. And you covered everything perfectly. Hope I'll be in touch. And I thank you so much. You're welcome to stay for the rest of the presentation, but I know how busy you are. So whatever you choose, we're glad to have you either way.
Thank you. Thank you very much. Good luck, everybody.
Thank you, Julie.
If you don't have us, you should have us. I'll just say it. Okay.
Yeah,
No.
okay.
Okay. So the handout you'll be receiving will go over some of the stuff and broaden this, but I really wanted to kind of hit some high points as far as the impact of COVID. Okay. I believe one of the things that we have to understand is that an emotional distress is a common and normal in context of something like COVID. And again, to that normalization. What are the things that we're looking at? Well, we're looking at what? Excessive worrying, excessive television watching. We're looking at hypervigilance, people checking their phones 15 times a day. You know, I tell people, look, check the headlines in the morning, check the headlines in the evening. That's all you need. You don't need to know, because let's face it, it's not going to be anything new on that 24-hour loop, right? You catch it a couple times a day, you've got the news. what we're looking for is people, like I said, if they're out of character, you know, they're usually gregarious, they're the kind of person that's always being good with customer service. All of a sudden you see them withdrawn, reach out to them, okay? Reach out to them. One of the things that we do want to look at too here, and I have to say this, you know, one of the things that we do is maybe some unhealthy coping mechanisms. You may see an increase in substance abuse, right? You may see a increase in absenteeism. I don't know. Now, you guys, this is a library system. I don't know. Are your libraries open? Do people come, or are you just having curbside pickup?
We're open. I think a lot of the employers on the call may be open to the public as well.
Okay. One of the things I think that we have to understand is one of the things that humans need is structure. All right. You talk about the impact of COVID on mental health. I believe the biggest impact has been our schedules are gone. What was normal is gone. The things that we used to use as a normal coping mechanism, hanging out with friends, going out for a meal, catching a movie, going to the gym, all of these things for months were removed from our society. We're only now here in Michigan coming back online, okay? So what we used to use and what our structured schedules used to be is now out the window. One of the biggest things we want to do is make sure that we're helping people understand the need for routine and structure in their life. As much as we like, oh, you know, I don't want to do the same thing. We need this structure. Okay. So as leaders, again, one of the things I think that you can help is, even as things are changing, communicate the changes, but also try to keep the structure as consistent as possible. The more we have this consistency, it kind of makes us feel like we have some hedge against the future. One of the things that COVID has taken away from us is this protection of thinking we have some control over the future. What do I mean by that? Well, when we have a schedule, when I have things on my calendar, when I know I'm going to have that meeting on Tuesday, when I know when I talk with Vanessa, this is who she's going to be. That consistency allows me to feel comfortable and safe. When that consistency is gone, now all of a sudden I feel very exposed. I feel very vulnerable, okay? What does depression look like? Depression looks like, yes, that normal withdrawal. Maybe people aren't sleeping well, but it also can express itself as anger. Okay, so we want to look at that as well. Do you have coworkers that, you know, usually pretty chill, but all of a sudden they just seem to be flying off the handle all of the time? Okay, again, this is another possible consequence of COVID on our mental health. We want to make sure that they're also, as they're reincorporating and they're structuring their normal, that they have the tools. Again, that's why I sent you this copy, this handout. There's some really, really good tools in there. There's also one on the back side, on the last two there, and I know you don't have it in front of you, and I apologize, I didn't get it out. There's two different assessments. And again, these are things that if you see an employee struggling, if you feel you're struggling, this is a beautiful, quick tool. This first self-check here is just a simple 14 question. And this one is specific to COVID. So this will give you a little bit more of that detail. I'm kind of rushing through this. I'm being mindful of the time here, but this is going to give you a little bit more detail of some of the things that you can be looking for. Now, if you or a coworker is answering yes to 6 or more of these questions on here, I highly recommend they give us a call or seek out some kind of help. Whatever the EAP is that you have, pastoral care, again, that community, look at what this is doing here. The other one, and I know, again, I apologize for going so quickly. The one on the very last page is a little bit more involved. And what this does is this looks at the phenomenon of burnout, okay? This is not our normal way of working. I mean, it's kind of becoming normal now with the Zoom thing, okay? But you guys are in a people kind of business. And so the more we remove ourselves from people, the more complicated things get. And so we want to make sure we're not burning out. And so this particular quiz or this self-test is, it's graduated. So you answer, you know, basically from not at all to very often, and you score it 1 to 5. Then down at the bottom, it gives you how to interpret the score, okay? Again, if your score on this quiz is 50 points or higher, give us a call, reach out to pastoral care, reach out to psychotherapy, if you have a psychotherapist, something like that, okay? How am I doing? Okay, so that's about my time. Questions, comments? I apologize again for having to kind of be here so quickly. Any questions or comments for me?
Have you noticed an uptick of people that, you know, because of COVID, more people are passing away? So they have to deal with the COVID and the grief. What are you seeing in that arena? And how are you kind of just basically, how would an employer deal with employees that are dealing with both of those issues?
Again, and I know this is going to sound weird, in this case, because of exactly what you said, Vanessa, we are experiencing what's called complicated bereavement. The normal processes that we use in our society to process the loss of a loved one and grieve and move forward, again, have been removed. We can't even go to the nursing homes where they're passing away. We can't go into the hospitals where they're passing away. We can't go to a funeral. Or maybe it's just Zoom. I just did a huge series of work with folks who are in long-term care facilities. They are the ones that are literally holding the hands of these people as they're passing away, and that's weighing on them. So this is an extremely complicated bereavement situation, and I would strongly recommend that they seek professional help. If they're really bonded and they have a good clergy person, that can be helpful. But in this particular case, I would again strongly recommend that they seek professional help. Good question. Thank you.
Thank you, Kevin. Does anybody have any questions for Kevin? Kevin, that was excellent. Anybody?
Yes,
Okay,
we
seeing
have
some
some
things that-
folks very interested in seeing the assessment, so I'll get those out, or Vanessa will ship those out to the group.
Yes, I absolutely will.
All right. And again, if this, you know, sometimes what happens is I come in, I kind of give my little 10 or 15 minute spiel, and then all of a sudden now this is going to raise a lot more questions. As I had reached out to, you know, we got this general, but the more specifics, like the thing about bereavement, that's beautiful. You know, what are you challenged with? What are the challenges that you're facing? So if you want to have me come back when we have a little bit more time to add, you know, to address maybe specific concerns, I would be very open to that.
That is so nice, Kevin, because we might have to take you up on that. And then that way that'll give me time to get the assessments up. So when you go over them, you can kind of give a little more detail. So
Yes.
Yeah.
That was my
I do
hope.
have one more question. Do you find that employees who have access to short-term disability in the workplace are asking therapists more to be off on short-term disability, or what are the, because we have a few workers that really have some mental challenges during this time, but not all the short-term carriers look at this as a disability.
And this is okay. First part of your question, absolutely. In fact, I've experienced about a 2.5 to 3 times 300% increase in FMLA requests. Okay. Second point, yes, companies are pushing back. I've been working with a company. I think it's Sun Life. My paperwork is doubled. Okay. But to the third part there, this is a disability from the standpoint that if it's not addressed, then what happens is it can become debilitating. The challenge oftentimes, let's take depression, for instance. If I'm depressed and I don't get relief from that, then it almost becomes what we call a negative reinforcement feedback loop. I'm depressed, I'm not getting any better. So what does that do? That makes me more depressed, right? I'm depressed, I'm not getting any better, it makes me more depressed. And so now we have this downward spiral. This will manifest not only in mental health issues, but this will also manifest in physical things. In that handout that I gave you, it talks about the autonomic nervous system a little bit, okay, about the parasympathetic and the sympathetic nervous system. If we are not managing this, we will start to have some serious physical injuries. Okay, and so now you're going to have people out who are even out for longer because they're dealing with both the medical, emotional, but now they are the mental and emotional, but now they also have a medical component to it. So absolutely, I've seen an increase in requests for FMLA, and I've also found a lot of pushback on those requests, or a lot more relative to what I've experienced over the last 15 years. Good question.
Anybody else?
I see that Katrina asked, do you have some tips on how to handle stress and anxiety? This handout that you will be receiving is filled with pages and pages of it, okay? Everything from little short breathing techniques to longer term healthcare things. There's one in here that I would strongly recommend, and it's called, and actually the nice thing about it for now, it's free, and it's called Headspace. You can get this on your phone, or you can get it as an app or anything like that. And for right now, Governor Whitmer is paying the bill for this. As long as the COVID thing is going on, you can get it for free. So I highly recommend it, but you'll see that there are several different things here. Again, I apologize. I'd hoped this would be in your hands by the time we had this meeting, and it didn't make it there. So, okay.
Okay, anybody else?
Well, we do want to thank you for coming to this session this morning after being out of the office yesterday.